understand, I can't really advise you about how all that works, but on an interlocutory appeal, the Court of Appeals doesn't get the court file. They only get that when there's appeals after a case is done. So if you're filing an interlocutory appeal, you got to file an application, and you have to attach to that application all the stuff you want them to see. They won't get the record unless they ask for it. All right. So otherwise, we'll see you all back on March 19th at 9 a.m.
And welcome to Facts or Frauds.
What you are witnessing is real. The participants are not actors.
Good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. And our first case on the morning docket is People of the State of Michigan versus Trevor McLeod, file 23-6748FH. Good morning, Mr. McLeod. And still your intention to represent yourself in this matter?
That's correct.
All right. And good morning, Mr. Juliet. And Mr. McLeod, this is scheduled for a docket call, but also you filed a motion to reconsider the court's denial of the motion to suppress. I've reviewed your motion. Go ahead and say anything further that you wish to in its support.
I mean, I think it's pretty well laid out in my motion to reconsider.
Thank you, Mr. Juliet. People have a position? No. All right. Well, Mr. McLeod, I mean, your motion to reconsider is that this court doesn't have the authority to interpret the consent decree, and that you don't have to announce your status as a tribal member to DNR officers in order to be protected by the provisions of the consent decree. I mean, I'm assuming that those statements that you make are true, you know, but it's my opinion that doesn't change the ruling in this case, because if you were charged with some kind of boat registration violation or something,
Which I was.
those may well be. Well, but that's not the violation that's in front of me.
Well, that's the initial violation for the whole reason why I'm here.
Right. But if you were charged with that, this might well present a defense. But what I'm saying is that doesn't invalidate the officers having contact with you, because they have no idea who's who out there.
Right.
To accept your argument means that they just don't get to just that tribal members could just go around and they don't even get to get stopped when the police don't even know who they are.
Well, I think this is because they're supposed to be trained to ask if we're tribal or not. Well, and in fact, in the consent decree, for them to even be qualified to handle or deal with tribal members, they're supposed to have cultural sensitivity training. And I can tell you right now that I've called my tribe and they're not on any list that's that has had that training. So they're not even qualified to approach or ticket or do anything with tribal members until they complete that training, and they've never done it. So,
well, the testimony was that the officer, immediately upon initial contact, did detect indications of impairment, and then
right. But I also proved that he perjured himself, which means his testimony is junk.
Right. So based upon his testimony, the stop was good, the investigation was good, and the motion for reconsideration is denied. So what that does, sir, I don't even know who you are, but you got to stop interrupting the process, correct?
I'm sorry.
Okay. You can observe, but you can't participate. You understand there's a difference there. All right. So, Mr. McLeod, then you previously stated that it was your intention to file an application to appeal the Court of Appeals, or are you still seeking?
Well, currently what's going on is I'm filing a criminal complaint against these officers and probably a civil complaint. So I'm going to make a move to stay in court, motion to stay in court for a bit while I get these complaints going and get them to the right authorities.
Well, I'm not going to do that. I mean, it's one thing, you know, sometimes when people are appealing a ruling, that's different, but you're saying you want to pursue criminal or civil remedies against the officers. I don't even know what those would be, but I'm not going to stay in this case for that.
Well, I've also got 5 more motions that I've already written that I'm returning to, so I need some time to sort this out.
Well, when are you gonna file those?
I'll file one today,
Well, here's the deal, like you should file all the motions you want me to hear, and then I can hear them. And then if they resolve the case, great. If they don't, then we'll set it for a jury trial. What we shouldn't ought to do is just kind of trickle them out, so this case lasts, 2 years or something. So what I was thinking I could do today is give you a jury trial. But if you've got some more motions to file, I'll put it out for another docket call, but that'll be a motion cutoff, meaning that any arguments you got about this case, file them all, and we'll hear them all. Does that make sense?
I guess so.
Okay. So let's pick a date for that. What about April 23rd? That's in about 5 weeks. That should give you plenty of time to get your motions filed.
Yeah, that's right.
Okay. All right. So let's schedule this then for a docket call. And that'll also serve as a motion cutoff for April 23rd at 9 a.m.
I'd like to have Officer Liestenfelds and Beelman present for questioning. Could I have Officer Liestenfelds and Officer Beelman present for questioning that day?
Well, it depends on what motion you file.
It's going to have to do with their testimony.
Okay, so if you file a motion that requires the testimony of the officers, then how that generally works is when you file the written motion, then the prosecutors, on notice that in order to respond to that motion, they have to bring the officers to testify. What motion do you think you're going to file that requires their testimony?
Well, I'm going to. So in Mr. Liestenfeld's report, which you probably have in front of you.
I don't.
Oh,
I only get what you guys give me during motions. So,
I submitted it all. It's all in the clerk's file. But he states in his statement that once the warrant was signed, that I gave him my blood without cause, but in my documents, I've got an unsigned warrant. It was never signed. So his testimony will be impeached also. They're both lying.
Okay, so you're going to file a motion to suppress was there a blood test? Okay, the blood test. Okay, and that would require the officer's testimony. So, all right. So yes, if you file a motion like that, Mr. J.D.L will bring the officers. Okay. Otherwise, he would probably lose the motion because it's his burden to come forward with that evidence. Then. All right. All right. Anything further today, then, Mr. McCall?
No, it's good enough.
Okay, we'll see you April 23rd at night. All right.
You can't fix stupid.
And thanks for joining us on Facts or Frauds. Make sure you hit the thumbs up button, you're subscribed, and ring that bell for notifications so the next time I premiere a video, you can be in the live chat with everyone else and leave a comment in the comment section, tell me what you think. And a huge thank you to all of our Facts or Frauds channel members. If you'd like to become a member, just hit that join button right next to subscribe or click on the link in the description. And if you're still hanging around, thank you. I appreciate you all. Why not hit that thumbs up button, subscribe, and ring that bell. And also leave a comment in the comment section, tell me what you think. Until next time, I'll see you soon.